Okay, it's October 21st, 2021 in ba230 fall, and we are going to be talking now about dispute resolution, alternative dispute resolution, and civil litigation. And we are going to use this fact pattern, which is on page 32 of the book, as sort of a case summary, or this is out of textbook. So now we're going to talk about how you go about resolving a civil. This is not criminal. Okay, criminal's different. A civil dispute, and up to and including a lawsuit. Okay, how do you go about resolving what potentially could be a lawsuit? And there are various methods for this. So we're going to use this fact pattern. So I'm not going to read the whole thing. You guys can read it to yourself, but I'll just give you some background on this fact pattern. This involves a life insurance policy. A life insurance is insurance that is paid when somebody that is insured dies. And typically, a life insurance policy will pay when the death is by natural cause, accidental, but not intentional. In other words, suicide is an exclusion under a life insurance policy. So this case involves several people. The first is Tony Caruso, or Anthony Caruso. He and, where is it, Elizabeth Smiles. Okay, so Tony Caruso and his partner Elizabeth Smiles were co-owners of a small business called EnviroVision. And as partners in the business, they had life insurance policies on each other. Those are called key person insurance policies, which is very common in small business. If we're in business together and you pass away, the life insurance will pay the company. That way there's cash flow to help maintain the business, and also to help buy out the family of the deceased partner, because I probably don't want to be in business with your children or your spouse. So I want to be able to buy them out, that way they're compensated, and then I can take over the business from there. So it's a real common scenario in the real world to have life insurance on your partners in a small business. So this case involves a situation where Anthony Caruso and Elizabeth Smiles were partners in this business. They had life insurance policies on each other. And then one day, as you can read here at the beginning, Anthony, or Tony Caruso, and his wife were down at the beach, and he went out for a swim, and he did not return. So his wife went out and hurried down the sand dunes a half a mile to the ocean. She came upon his dog Blue tied to an old picket fence. His shoes and clothing were piled neatly nearby, and they searched frantically throughout the evening. A little past midnight, Tony Caruso's body washed ashore. At that point, he was deceased, and local physician determined that he had accidentally drowned. So, Tony Caruso's partner, Elizabeth Smiles, had this life insurance policy. So she filed a claim with a life insurance company, right here, for $2 million under the life insurance policy. It's called a $2 million accidental death. $1 million in the event of natural death, like a heart attack or something. $2 million accidental death, accidental drowning. So she filed the claim for $2 million. After a few months, she got a response from the insurance company that said, essentially right here, under the policy issued to EnviroVision, that's their company, the insurance company is conditionally liable to pay $1 million in the event of Mr. Caruso's death. If his death is accidental, we are liable to pay double the amount of $2 million, but pursuant to Section H5 of the insurance policy, suicide is not covered. And then the insurance company wrote back, after investigation, the insurance company concluded that Anthony Caruso's death was an act of suicide, and therefore the claim is denied. All right? So in other words, they're not going to pay the money. Now, this is a dispute. So let's say Elizabeth Smiles now wants to take legal action against the life insurance company for not paying on the policy. That's a breach of contract case. That would be civil, not criminal. And so, let's say she comes to us as lawyers for us to assist her in trying to get the insurance company to pay this money. So now, that is the background for the dispute that we're going to be talking about as we work our way through civil litigation, how that works, and other methods of dispute resolution. So we're going to use that as our factual background. Okay, so she comes to see us. So now we are going to try to assist her in getting her money from the life insurance policy. Now, this is on page 25. So one thing we could do, now we're all law firm now, okay? You guys are all my partners in the law firm. It's got promoted. So we could just file a lawsuit against the life insurance company like right now. And that may be what we do. But sometimes, and actually most of the time, it's not really the correct first step. And so there are alternatives that are utilized in the real world, and this is becoming the trend, and has been for decades, in resolving disputes outside or as an alternative to litigation. Okay? So litigation. Litigation equals a lawsuit. So when I use that term litigation, I'm referring to a lawsuit. So that is one option. We could sue the life insurance company, literally put together a complaint, file it with the court, and just start out with a lawsuit right away. Now, there are alternatives. Alternative dispute resolution. This is abbreviated as ADR, by the way. ADR, that's kind of the abbreviation, or acronym, I should say. Alternative dispute resolution. So these are alternative methods to resolve a dispute instead of going through the court system, or as an offshoot of the court system, as we'll talk about more as we progress. So these are alternatives to litigation, that is using the official court system or going to a trial. Now, with that said, why? Why would you want an alternative to going through the official court system? What are the downsides to going to court? There are a number of them. But can you think of some major downsides why you might want to use an alternative method? Anyone? What was it? Expensive. Okay, expensive, absolutely. That's probably close to the number one answer, survey says. So, it's expensive to go to court. And first of all, you got to file the lawsuit. You got to pay a filing fee to the court, which may be hundreds or even thousands of dollars just to file the case. You got to pay a lawyer to write up the case. And then as you work your way through, there are discovery and all sorts of additional costs, and it gets very, very expensive. I mean, very expensive. So if you can settle your case outside of court, it saves you all of those type of expenses. So that's one, money. What's another one? Anybody know? Time. Time equals money, right? But yeah, absolutely. Filing a lawsuit takes time for a couple reasons. Number one, our courts are really backed up, especially post-COVID. We've got a huge backlog of cases. But also, even pre-COVID, the courts are very backed up. And so it takes a lot of time. On top of that, as we're going to learn as we talk about civil litigation, there are time requirements built into trial court rules of civil procedure. So for example, if I sue you, I file a lawsuit, I serve you with the papers, you then have 30 days to respond, and then I have 30 days to respond to your response, and then we have time limits that are built into the civil procedure code that create this time lag. Just to give you an idea, pre-COVID, I don't really know what it is now, but pre-COVID, getting to trial here in Polk County took about a year, which is actually pretty quick. There are some jurisdictions around the country that were 3 to 5 years to be able to go to trial on a civil case. Yeah, it just takes forever. So time, money. What's another one? When you file something in court, it becomes what type of record? Public, right? Other than juvenile cases and some type of family law cases. So a trial, a civil lawsuit is in a public court. The documents that are filed are typically going to be public record. There are some exceptions to that if a judge issues a non-disclosure order. But for the most part, those are going to be public record. You can go in and watch the trial, or it may even be put on TV. So there's publicity involved. And so you may not, if it's a sensitive case or you've got maybe formulas involving chemicals or a recipe or something that you don't really want out there in the public realm, like your secret recipe for fried chicken, Kentucky Fried Chicken or whatever. Maybe they don't want that out there. If it becomes public record, now the whole world's going to know what it is. So time, money, publicity. There's another reason why you might want to use one of these other methods, and that is it helps give you input over how the final solution, the final outcome. Where if you go to court, a judge issues a decision, you win, you lose, neither side may like that. So the ability to craft your outcome that may be beneficial to both sides, or at least both sides can compromise and agree to it, rather than just having, this is how it is and whether you like it or not. So utilizing these methods can help allow input and actually working together to create an outcome as a settlement that everybody can live with. It also avoids one of the problems of going to court is it's adversarial in nature, meaning it's me against you instead of us working together. And that's really important, like in family law, like custody cases, where the parents try to work together rather than them beating heads together in court. They can meet with the mediator and work out what's going to be best for the child, what's going to be best for their schedule for work and holidays, and do that in a cooperative format as best as possible with all the emotion. So there are various reasons why we use these, but probably the biggest 4: time, money, publicity, and the ability to be involved in the outcome, or less adversarial is probably a better way to say that, because the court system is a very adversarial process. All right, so with that said, let's work our way through these a little bit. So first of all, you'll notice I have 100%. Fill in the blank question. It's pretty common. Oh, no, I always ask this. What are, usually I'll ask for 4, sometimes 6 methods of dispute resolution in a civil case? Or what are 6 methods of dispute resolution? And so that's what I'm looking for off of this page. Now, the main ones I want you to know I have highlighted. That is settlement, negotiation, mediation, and arbitration. The reason why I have those highlighted, those are kind of the main ones. The rest on the page are derivatives or variations of those 4. And sometimes they're the same thing, they just go by a different name depending on what state you're in. So let's start off at the top with settlement. Make sure my video is still going. Yeah. Okay. So settlement. Now, settlement in and of itself is not really, well, it is, but it's not a method of dispute resolution. It's the outcome that you're hoping for. So when I say settlement, what I mean by that is essentially an agreement between or among the parties involved in the dispute about how they will resolve the dispute, either before a lawsuit is filed or even after a lawsuit is filed. So the idea of settlement is an agreement by the parties on how they will resolve the case. First of all, what I want you to know is most cases that could lead to a lawsuit going to court are settled. I mean, easily high 90 percentile. I mean, I've been practicing law now 30 years, wow. And easily 90%, 95, 98% of the cases I've been involved with settle. And what I mean by that is we reach an agreement, we never go to court, okay? So most cases are resolved through settlement. Now, settlement in and of itself is not necessarily a technique. Some of these are techniques to help you get to a settlement, a facilitated settlement. But here's a couple things I want you to know about settlement. Number one, a case, for the most part, can be settled at any time. Now here's what I mean by that. Let's say we have an automobile accident. I'm walking in the crosswalk, and you're driving down the road, and you're not really paying attention. You're playing with your radio, and you're eating a cheeseburger and whatever. And you don't see me in the crosswalk, and you run into me. And you break my leg, okay? You didn't do it on purpose, so it's not a criminal thing. But nevertheless, you will be liable to me for negligence, for breaking my leg with your car. Now, I could sue you, but there's sort of a paradigm here, okay, a timeline. So the event occurs, automobile accident, I get a broken leg. So I could sue you, but before I do that, we're going to try and settle the case. So we could settle the case pre-lawsuit. And we'll talk more about that in a minute. Maybe I decide I'm going to go ahead and sue you right away, so I file a lawsuit, but we haven't gone to trial yet. So we're in pre-trial. We can settle the case. Let's say we're now scheduled for trial, and it's the morning of trial, and we meet at 8:45 in the morning in the hallway. Trial's going to start at 9 o'clock, and we work out a deal in the hallway. I've literally done that. And we settle the case. We go in and we tell the judge, Your Honor, we have settled the case in the hallway. We're going to read the settlement into the record, and then we don't need the jury anymore because we've settled. That's fine. Judges actually like it when the parties settle a case on their own. Takes it off their docket for one reason. Okay, now we're in trial. We can still settle the case. I've had cases, literally a 4-day jury trial. We're on day number 2. We've picked a jury. They're sitting in the box. We've called witnesses already. And I had one case where I went out to lunch with a lawyer on the other side, who actually I knew from law school. We're opposing each other in court, but we went to lunch. And over a teriyaki bowl, we literally worked out a settlement. True story. Went back in at 1:15, told the judge over lunch we were able to work out a settlement. The judge dismissed the jury, and again we read it into the record and it became a settlement. So in the middle of trial, the judge was quite happy actually. All right, post-trial. Somebody wins, somebody loses. You can still settle the case. Instead of appealing, you settle it post-trial. You're up on appeal, you can still settle, even all the way to the U.S. Supreme Court, or even afterwards. There's nowhere left to go. But a case, the point I'm making, is a case can always be settled. It just becomes harder and harder to settle the longer you're going down this litigation roadway, if that makes sense. And part of the reason why is as you're going down the litigation path, you have so much money invested into the dispute in terms of attorney fees and costs, private investigator expenses, discovery fees and costs, that the only way you can recoup that is to win. And so that's why it's really important, at least from my viewpoint, if you can work out a settlement at the very beginning of a dispute, or at least the early part, you're going to be money ahead, almost every time. So I'll get off my rant there, but that's one of my rules at the bottom, down here. Case could be settled at any time. Now, with that said, how does this go about? So, back to the insurance company case. So if we're now the lawyer for Elizabeth Smiles, the first thing we're going to do is I'm going to write a letter to the life insurance company. It's called a demand letter, right here. A demand letter. And in that letter, I'm going to basically say, I have been retained by Elizabeth Smiles to act as her attorney. We've done an investigation which has determined that Anthony Caruso died while accidentally drowned. We have no evidence to the contrary. Under the terms of the life insurance contract, you are obligated to pay $2 million. We are hereby demanding that you pay the $2 million by sending a check to me payable by lawyer trust account on behalf of my client by Monday, this coming Monday. And if we have not received that check by Monday, we will be filing a lawsuit. And in the lawsuit, we are going to ask for the $2 million together with punitive damages for bad faith in not paying the money out based upon accidental death. And we're also going to ask for attorney fees and costs. So you have till Monday to send me a check, basically. So that's how I would start the case. I would send a demand letter to the insurance company, hoping that we can settle the case. Now, when a case is settled, typically there will be an agreement that is written up, which is called a settlement and release agreement. This is a contract on how the case will be settled. So if it's an automobile accident, again, you ran me over with your car, you broke my leg, I send a letter to you threatening to sue you unless you pay me, $200,000 by Tuesday or whatever. So that's actually going to end up going to your insurance company. Your insurance company will then negotiate with me. And if we reach an agreement, we will sign a settlement and release agreement, which basically says your insurance company will pay me whatever money plus my medical bills, lost wages, and in exchange, I release you from all further liability. So that's the exchange, money in exchange for a release. As part of that, if I also would agree not to file a lawsuit, or if I have already filed a lawsuit, I will agree that I will dismiss the lawsuit as part of the settlement. So when you reach a settlement, you enter into an agreement, which is a binding contract that is enforceable by a judge. A judge can enforce that settlement as a matter of contract law. All right. So again, most of the time, a case discussions will be initiated through a demand letter, which hopefully will lead to a settlement. So that brings up negotiation. Negotiation, when I use that term in this class, what I'm referring to is direct communication between the parties in the dispute or their representatives. In other words, there's no third party in the middle facilitating the settlement. Most, 90% again, most cases are resolved through negotiation, usually by the lawyers, or if the insurance company is involved, it would be the lawyer for the injured party, the plaintiff's lawyer, and the insurance adjuster, usually before it goes to court. So again, I'm going to send a demand letter to the insurance company, and I'm going to basically tell them, I'm going to sue you unless you pay up, and if you don't pay up, we will file a lawsuit. So that's when the negotiation will begin. So I would write them a letter, I tell them I'm going to sue you for $2 million. They might write back a letter saying, well, we have a video that makes it look like he did this on purpose or whatever, but we're willing to settle it for $1.5 million or something. So that brings up my rule of negotiation down here at the bottom. John's rule of negotiation. Do not bid against yourself. Let me explain what I'm talking about. All right, so let's say I write the insurance company a demand letter and I'm demanding $2 million to settle the case. So they write me back a letter, and they say in their letter, no. So I write back another letter, and I say, okay, well, how about 1.9 million? And they write me back a letter, and they say, niet. I said, okay, well, geez, how about 1.8 million? 9. All right, how about 1.7 million? None. How about 1.6 million? You get the idea, right? Is that negotiating? No. That's like me going to an auction. I used to raise cattle. I don't anymore. But I'd go to the auction every spring and buy calves when they're about 400 or 500 pounds, and I'd raise them up until they're about 1,500 and sell them. So I go to the auction, primarily in Corvallis. They don't have it anymore, but I'd go and I'd bid on, let's say, a 500-pound calf. $500. So I'd raise my hand. And the auctioneer would say, okay, 550. So I'd raise my hand again, right? I'm the high bidder already. You'd never do that. You're bidding against yourself. Same thing. This is bidding against yourself. You are not negotiating. Now, maybe you're learning how to say no in a few different languages. That's kind of cool. But other than that, look, every time they're just laughing. I write a letter, they save 100 grand. By saying no. That's not negotiating. That is bidding against yourself. That's not good faith negotiating. Now, I see this all the time. It's in real world all the time. I see it in used cars. I see it in real estate. I see it all the time. It may not be, oh, flat out no. It may be, oh, is that the best you can do? Or some other platitude where you're not getting a counteroffer. That's what I'm leading up to. So true negotiation is offer, acceptance, or if there's no acceptance, counteroffer. Right? So if this is happening to you, I write a letter, I will settle for $2 million. They say no, I'm like, okay, fine, I'll write a follow-up letter. And I would say in the follow-up letter, I'm going to give you another opportunity to take advantage of my settlement offer of $2 million. If you do not settle with us by Monday, I will file a lawsuit. We will, however, entertain a counteroffer, but I will not bid against myself. I made you an offer. You can respond with a counteroffer, or you can go ahead and reject my offer, in which case I will sue you. Either way, I'm not going to lower my offer until you've responded. So at that point, we start getting into the negotiating. So I say $2 million, they may come back and say, we'll settle for $1 million. And I go back then and say, oh, well, I won't take $1 million, but we'll take 1.9, and then they say 1.1, and we start negotiating, right? That's true negotiating. This no thing, that's not really negotiating. Now, flip side, this is actually a taught technique. I don't know if there's a term for it, I call it the no technique, but if you're on this side, right, you're laughing at the other side because you're getting, every time a letter goes out, you're making money and you're not even giving anything up. So be aware of that technique. I see it done all the time. Like I say, everything from insurance to used cars to real estate to business deals, whatever. Just be aware of it. If you made an offer, you should only accept a counteroffer, a rejection, or an acceptance. Don't bid against yourself. Okay, enough on that. So, negotiation, by far and away, the most common method of resolving a dispute. Now, the next two, let's get into those. The next two, mediation and arbitration. These are both becoming very, very popular methods in all areas of business, real estate, construction, and outside of business, family law. Very, very common. In fact, in some cases, they are required by the judge as a court-ordered mediation or court-ordered arbitration. So I want you to know the difference between the two, because in some ways they're similar, in other ways they're very different from each other. So first of all, we have mediation and we have arbitration. Both of them involve having a third party in the middle. So let's look at mediation. So let's say we have a dispute. Pi and delta, okay? Pi is plaintiff, delta is defendant. So let's say this person, delta, ran over pi with their car. So pi is going to sue delta. So we can negotiate. In that case, there's nobody in the middle helping us. One method is to use a mediator. A mediator is a neutral third party, and their job, as the name implies, is to mediate or to be an intermediary between the two sides in the dispute. And so a mediator typically will be a retired judge or a lawyer that is an expert in that field of law, but it doesn't have to be a lawyer or a judge. It can be a doctor, an architect, it could be a real estate agent, it could be a contractor, a builder, it could be a chemist, it could be a musician, it could be a politician, it could be a pastor or other clergy person, it could be a counselor. The idea of mediation, not really necessarily related to law, is that you have a neutral third party in the middle that is facilitating the discussions between both sides to try to work out a deal. I call it a brokered settlement. And again, we see this everything from international relations to family law, having a family counselor act as a mediator for custody cases. So the idea of mediation is not just in law, but it's very common in law, in legal disputes. So the thing about a mediator that I want you to know, they are neutral. So I'm going to put an equal sign, meaning they're neutral. Now the reason why I say that is the mediator does not represent either party. Their sole job is to listen to both sides and try to get them to work out a deal. They're not going to advocate for either party, nor are they going to necessarily say, hey, here's a good idea, why don't you try this? They will suggest solutions to test out the waters, so to speak. So for example, a mediator in our insurance case, we would hire them. Let's say it's a retired judge. Each side will typically agree to pay half of the mediator's bill. There are companies that will provide mediators up in Portland, and branch offices in Salem. A mediator may be a retired Supreme Court justice. I used to use an Oregon Supreme Court justice that was retired for mediation. At that time, this was 20 years ago, charged $500 an hour, probably $1,000 an hour now. But these are multi-million-dollar cases, so if we can settle a case in mediation, we save hundreds of thousands. So the mediator, neutral third party, and here's what I want you to know. The mediator will not make a decision. In other words, the mediator is going to hold a mediation, meet with both sides, hear out their case, and try to work out a settlement. But the mediator is not going to say, okay, you win, you lose. Here's the outcome. It's up to the parties to reach an agreement. If they cannot reach an agreement at mediation, the mediation is called off, and then you go to trial. So the mediator's job is to be neutral, to suggest outcomes, but not to say, here's who wins, here's who loses. Now, arbitration is similar. So in an arbitration, again, you have a neutral third party. But now, an arbitration is like a private trial. And a private, instead of going to a judge, you have an arbitrator decide the case. The arbitrator will act like a judge, will review the evidence. You may actually have what's called an arbitration, which is like a trial where you'll call witnesses. Nowadays we do that by Zoom mostly. You submit written documents and testimony and videotapes. And so the arbitrator will listen to legal arguments that both sides makes, just like you do in a regular court trial. But the arbitrator will not act as a mediator. The arbitrator is going to make a decision. Who wins, who loses, how much money. The mediator will not do that. The The mediator will say, here's what I recommend. If the parties can agree to it, great. So what is the difference? So this is what I want you to know. Mediator, neutral third party, but they will not make a decision. If you can't reach a settlement, mediation's called off. Arbitration, neutral third party will review the evidence like a judge. It's kind of like a private trial, and will make a decision, whether you like it or not. Okay, see the difference? Now, both of these are very common. Nowadays, we are finding almost every state, before I get there, MEDARB. Sorry, jumped ahead myself. So there are hybrids. A MEDARB is a mediation arbitration. That's where the parties agree ahead of time. We're going to mediate for, let's say, the morning, from 8 a.m. until noon. And if we haven't reached an agreement at lunchtime, we're going to break for an hour and a half. And during that time, the mediator is going to turn into an arbitrator. Same person, but now they're going to come back after lunch and give us a decision. Now, the reason you do that is, first you try to work it out during the mediation phase, knowing that if you can't work it out, a decision will be made for you, whether you like it or not. It's a very powerful technique. Now, both sides would have to agree to that ahead of time for that to work properly. And then there'll be a contract that you draw up. All right, the next one. Court annexed or court mandated. Court mandatory, mediation, and arbitration. What I mean by that, this is becoming common throughout the United States, including Oregon. In many different types of cases, we now have a requirement that a judge will require the parties to a dispute to go through mediation and or arbitration before going to a regular trial. For example, custody cases. In Oregon, the parents in a custody dispute, before they can go to a trial, they have to go through mediation to try to work out child custody with the mediator, which is usually either a lawyer or a social worker or a counselor, whatever. So somebody that's going to help them work out a parenting plan, custody, all that kind of stuff. And that works really well, especially in custody cases, because that way the parents, they're not beating each other up in court. It's done privately. Everybody has an opportunity to talk. They can be separated. Works very well, less antagonistic. We also have court mandatory arbitration. In Oregon, if you file a lawsuit for less than $50,000, you have to go through arbitration first before you can go to a trial. And the idea behind that is to take cases out of the court system so judges have more ability to handle other type of cases. And also, again, to cut down on the emotion and antagonistic adversarial side in family law especially, that kind of thing. All right, now the rest of these, I'm not really going to test you on them. These are just different variations of mediation or arbitration. So like a private panel, that may be a panel of experts that we would hire. Maybe it's a dispute about a chemical formulation. So we hire a chemist and a chemical engineer and a patent lawyer, and they will act as a panel of three to decide a case. That's a form of arbitration. Or we may have a neutral evaluation where we have an expert lawyer give us evaluation on the validity of a case. We may have a private trial. This is, big companies like, let's say Chevron is suing Shell Oil over a gasoline formula, or Apple is suing Microsoft, and they don't want all this information out there in the public, so they'll sign non-disclosure agreements. They'll hire a private judge and have a private trial, and the outcome will never be disclosed. I mean, those kind of things. Some of these are really high-dollar cases. So these go by different names. I'm not really going to test you on the differences. It's these first four that I really want you to know. And that is, just to recap, don't bid against yourself. A case can be settled at any time. Mediation, neutral third party, no decision will be made. Arbitration, neutral third party, like a private judge or a private trial, a decision will be made. So those are kind of the main four I want you to know. All right, we are out of time, so I'm going to break there for today. And next class, we will pick up with how a civil lawsuit works.